You think court is the only way to finish a divorce?
If we can't agree, don't we have to fight it out in court?
Not always. There are two very different paths, and choosing wrong can cost you time and control.
This is general divorce information. Laws vary, so check with a legal professional in your area.
Laws vary, but smart strategies don't. This channel helps you avoid common mistakes and make better decisions during divorce. Episode 7. We'll look at two paths people often confuse: arbitration divorce and contested divorce. So now, let's get into today's episode. In this episode, you'll learn how contested divorce and arbitration actually work step by step, who makes the decisions in each process, and how much control you really have. The key differences in privacy, timing, and how cases move forward, and the risks, including what happens if you want to appeal.
I thought if we don't agree, it just goes to court. What actually happens?
That's a great question. Let's take a look at what a litigation divorce, meaning going through court, actually looks like. There are 8 basic steps. Step 1, filing and service. Step 2, response. Step 3, discovery. Step 4, temporary orders. Step 5, negotiation or mediation. Step 6, pretrial. Step 7, trial. Step 8, final judgment. That's the structure.
Okay, but what does that actually mean?
It starts with filing something called a petition for dissolution of marriage. That's a legal document telling the court, I want a divorce, and what you're asking for, like custody or property. Then the other spouse is officially served. A process server or sheriff delivers the papers. Your attorney usually arranges this.
When do people hire an attorney?
Many hire one before filing the plan strategy. The attorney talks with you, understands your situation, and helps you avoid mistakes. Others hire one right after being served. The attorney prepares and files the response to protect your rights.
What is discovery?
Discovery is the process where both sides exchange detailed information. This includes bank accounts, credit cards, retirement accounts, income, debts, property, and sometimes business records. Your attorney can send written questions called interrogatories, request documents like tax returns and pay stubs, and ask the other spouse to admit or deny certain facts. There can also be depositions, where your attorney asks questions in person under oath, and everything is recorded. The goal is to make sure nothing is hidden, and both sides have a clear, complete picture before any decisions are made.
What are temporary orders?
While the case is ongoing, the court can make short-term decisions. For example, custody, support, or who stays in the house. Your attorney files a request, the court sets a hearing, and the judge makes a temporary decision based on evidence like income. These decisions can influence the final outcome.
Do most cases go to trial?
No. Most cases try to settle through negotiation or mediation. Even though it's contested, the goal is to avoid trial. Communication usually happens through attorneys, not directly. A mediator may help both sides reach agreement. If you want a deeper look at how mediation works, with or without attorneys, we cover that in episode 5 on mediation divorce.
What happens if they still can't agree?
Then the case moves into pretrial. Pretrial is still part of the court process, and a judge is involved. These are meetings or short hearings where the judge checks the status of the case, reviews what issues are still unresolved, and may make decisions on smaller matters. It's also a point where the court encourages both sides to settle before going to trial. But this is not the full trial. You're not presenting the entire case yet, and no final decision is made on everything.
So if nothing is resolved at this stage, does the case move forward to trial?
At this point, you are on the court schedule. That can mean waiting weeks or even months for a trial date, depending on how busy the court is. On the day of trial, both sides go to court with their attorneys. Each side presents evidence. This can include financial documents, messages, and other records. Witnesses may be called to speak, and both attorneys ask questions to explain their side of the story. You don't speak freely whenever you want. Your attorney guides what is presented and how. The judge listens to both sides, reviews the evidence, and then makes the final decisions on issues like custody, support, and property. Sometimes the judge decides the same day. Other times, you may have to wait days or weeks to receive the final decision. Your attorney reviews it and explains your rights and obligations. If there was a legal mistake, an appeal can ask a higher court to review it.
I think I understand the steps. But can you walk me through a real story so I can picture it more clearly?
Sarah decided she wanted a divorce and met with a family law attorney.
I'm most worried about my son.
Her biggest concern was custody of her 6-year-old son. The attorney filed the petition for dissolution of marriage to start the case. Her husband, Mike, was served with the papers. He disagreed with what Sarah was asking and hired his own attorney.
I want equal time with my son.
Mike wanted 50-50 custody. Sarah wanted primary custody.
I don't think that's best for him.
During discovery, both sides exchanged financial records. Sarah believed Mike was hiding bonus income. Mike denied it.
Something doesn't add up.
That's not true.
Sarah's attorney questioned him in a deposition, where he had to answer under oath like in court, and everything was recorded. Even after that, they still disagreed. The court issued temporary orders. Sarah had primary custody for now, and Mike had scheduled parenting time. They tried mediation, but it failed. They could not agree on custody or income.
We're not getting anywhere.
I'm not agreeing to that.
The case moved into pretrial, where the judge reviewed the issues and encouraged settlement. But they still couldn't agree. So what happened next? The case went to trial. Both attorneys presented evidence to the judge.
Primary custody is in the child's best interest.
He should have equal parenting time.
Sarah's attorney argued for primary custody and showed financial records. Mike's attorney argued for equal parenting time. Each side questioned the other and presented their case. The trial may take one day or several. Sometimes it pauses and continues days or weeks later. Once all trial days are finished, the case is submitted to the judge. Then, they wait for the decision.
I keep going over everything I said.
Same here.
Behind the scenes, the judge carefully reviews everything presented. It might come soon, or it might take time. And when it comes, whether they agree or not, they must follow the order.
So if trial means a judge decides, is there another option?
Yes, it's called arbitration. In arbitration, you and your spouse still don't agree. But instead of going to court, you hire a private decision maker called an arbitrator. This person is often a retired judge or experienced divorce attorney.
So it's like a private judge?
Exactly. The biggest difference is this. You and your spouse choose who decides your case. In most cases, the decision is binding. That means once the arbitrator decides, it becomes final, like a court order. And there are very limited ways to appeal.
Why would someone choose this?
It's private. It's usually faster than court. And you can choose an experienced decision maker, especially for complex finances.
Are there risks?
Yes. You are giving a lot of power to one person, and you usually cannot appeal just because you don't like the decision. Also, if someone is hiding assets, the process may not be as strict as court.
What about child custody?
In some cases, an arbitrator can decide, but the court can still review it to protect the child's best interest.
What about cost? Is one cheaper than the other?
Not always. Many people assume arbitration is cheaper, but the total cost can end up being similar to going through court. In a contested divorce, you pay attorney fees and court-related costs. If the case goes to trial, attorney fees often increase. Some attorneys charge a higher hourly rate for court appearances, and even if they don't, the extra time in court can raise the total cost. In arbitration, you still pay attorney fees, but instead of court costs, you pay the arbitrator directly. Attorneys don't go to court in arbitration, so you usually don't see a separate court rate. But the overall cost still depends on how much work is involved. In many cases, both options can cost around $10,000 to $30,000 or more. The total depends on how complex the case is and how much you disagree.
So based on all this, how should someone decide what's right for them?
It comes down to trade-offs. Trial pros, stronger legal protections. More formal discovery to find hidden assets, full right to appeal if something goes wrong. Trial cons, public process, takes longer, can be more stressful and expensive. Arbitration pros, more flexible scheduling so cases can move faster. Private process, you can choose the decision maker. Arbitration cons, very limited appeal. Less strict discovery, switch can be a risk.
So it's really about what matters more.
Exactly, protection and structure or speed and privacy. And the more you can agree, the more control you keep.
In the next episode, we'll show you how to choose the right divorce attorney. Because higher hourly doesn't always mean higher total cost. Discounts aren't always better, and knowing what to ask and how to prepare can completely change your outcome.
When you understand the road ahead, you can guide your divorce in the direction that truly works for your life. And even if you hire a great attorney, you should still stay in the driver's seat, not the back seat where you can't see where things are headed. But you don't have to go through this alone. The right knowledge at the right time can change everything. Laws vary, but smart strategies don't. Divorce information. Always by your side.